everybody, and welcome to this week's episode of Nicci Chats 2. My name is Nicci Stewart, for those of you who don't know me, and I have these weekly chats with various people who I find very interesting and who I find have got interesting things to say or insights into a particular topic. Generally, I work with companies to help them leverage their sustainability to build their brands, but I'm also very passionate about shifting perspectives, which is the purpose of this podcast. So today I am joined by a friend of mine, Clem Daniel, and the reason why I have asked Clem to come on today is to discuss something that I feel very passionately about and something that has caused great anger and frustration, and I think a lot of confusion around the world, which is the overturning in the USA of the Roe Vs Wade judgment. So Clem and I are going to be talking about that today. Clem, welcome. Thanks very much for being here.
Thanks, Nicci. Thanks for inviting me, and thanks for the opportunity to talk about this. I think it's quite an interesting topic with quite a lot of nuances around it, and I suspect that in the public debate, a lot of that nuance has gone missing. You know, there's sort of people assume a point, or they think they understand what the debate is really about, and it was against that background, some people sort of said to me, well, what do you think? And I thought, well, I'd better go off and actually read the judgment first.
So just to give you a little bit of context on Clem and why I did specifically ask him, Clem is a director at Cliff Decker Hofmeyr, which is one of the big law firms here in South Africa. But he's also had quite an unusual and broad range experience in law. But Clem is one of those people who I consider to be incredibly well-read and incredibly curious. And so he's got a very broad knowledge, a very educated knowledge of a number of topics. And I would highly recommend you follow him on Facebook if you are interested, because he's made some fascinating commentary about this topic, but the war in the Ukraine. And yeah, he's just a pretty cool individual to connect with. But this is why I specifically asked Clem to chat about this, because as you know, generally I do interview women. So Clem is one of my exceptions. But yeah, I really wanted to get his very educated and very well-researched and well-read opinion on this. So Clem, thanks very much. So let's, I mean, to kick this off and get straight into it, firstly, if you're comfortable to start here, if you want to start somewhere else, by all means. What I want to understand is how did this judgment get overturned? What was the sort of build up to this, and how did this, what some people like myself consider to be a monumentous event, actually happen?
Nicci, it's got, Roe versus Wade is a decision that was an opinion of the US Supreme Court. They talk about opinions rather than decisions.
Okay.
In 1973. And at that point in time, it was a very momentous decision. It was, it broke with the legal position as people had understood it. And it created, I think, a certain degree of schism in American society. And I'll come back to that in a moment and I'll explain it. Which created a lot of tension because people have very different views around this issue. You know, they're very different sets of perspectives. And it's an issue which has created a lot of division. And so I think there has always been a degree of debate about Roe versus Wade. And Roe versus Wade was founded on, I think, a very expansive reading of the American Constitution. And didn't really find traction in the wording of the Constitution as such. And so a lot of people, even pro-abortion scholars, had recognized that it wasn't the most well-reasoned from a legal perspective. I'm not talking about the underlying moral values and how people may perceive that, but from a pure legal perspective, it wasn't as well-founded in the perspective, in the view of many legal scholars, including those who are very pro-abortion. And it was perhaps always going to be open to challenge. I do know that Ruth Ginsburg herself had some misgivings about Roe versus Wade. Not necessarily on the judgment perspective as such, but she felt that it interrupted the liberalization debate, which was then occurring around this issue in the United States. You know, at that point in time, about 3/4 of the states had laws which prohibited abortion in some form or another, and at some point or another. But there was a slow move towards liberalization at that point in time, and there was a lot of public debate about it. And she did intimate that she thought that Roe versus Wade had interrupted that process because it had changed the legal position as people understood it then fundamentally, and interrupted that process of public debate and, you know, how do we reach a point of consensus. And in fact, that is something that Justice Alito's judgment, which is the majority decision in Dobbs versus Jackson, which overturns Roe versus Wade, that is something that he speaks to in some depth, and you know, I'll get into the detail of that shortly. So there is that perspective that Roe versus Wade interrupted what was a democratic process of, you know, trying to create that sort of consensus. And what this judgment seems to do, what the decision seems to do, is to really return to that democratic process and to say, this is not an issue which you will find addressed in the American Constitution. And this is something that the people need to decide for themselves through democratic processes. In other words, we try to persuade each other on the ground of the rightness of our views, and then we vote on it. And the way we vote on it is we elect our representatives. And in the various states, those representatives then make laws which represent the views of the people.
Okay. So that's, sorry to interrupt you. So that's what you mean when you talk about liberalization in the democratic process. It's the people's right to choose which way to go, as opposed to instituting this kind of blanket ruling around this.
That's right. And as I understand Justice Ginsburg's view on it, and I haven't read extensively on the subject as to what her views was, something that I have picked up in, you know, media articles and so forth. She was of the view that there was this discussion happening about abortion at grassroots level in the US and in the democratic process, and people were moving away from the very conservative view around abortion towards a more liberal view, and that this process could have continued, and if that had been permitted to continue over a few decades, you may not have ended up with this very blue versus red debate which we are having today around this issue. That there may have been a middle ground or a consensus. And if you look at Roe versus Wade and the subsequent decision of Casey, which overwrote some of the principles of Roe versus Wade, but Casey really tried to put an end to this debate in the United States, to try and diffuse it, but didn't succeed in doing that. And Casey is another decision which is dealt with in Justice Alito's case. But fundamentally, when you unpack this thing, and if you want to look at it at its most macro level, there are two different ways of interpreting a constitution. And, you know, jurists differ on this. And there is a view which says, it's sort of an originalist view, which says what was intended at the time that the Constitution was written or the relevant amendment was made, what was in the minds of the people at that point in time, and you interpret it against that background in that context. A different view says, well, a constitution is a living thing and you must reinterpret it on an ongoing basis as society develops and changes and new things evolve and new technology and new science and as values change. And when you look at Justice Alito's decision and you look at the minority decision, you will see that there is this different philosophical view, and it is something which is much debated, particularly in the US, as to which is the correct approach. There's reams and reams of material on the subject.
Wow.
So, you know, that's sort of the background against which this decision occurred. And the key elements of this decision really turn on a view by the majority that you will not find in the United States Constitution a provision which expressly allows for abortion, or more correctly, prohibits the individual states from regulating abortion under their own. That's the core principle. And the court says there is no such principle in our constitution. I'll go into the detail of how they arrive at that in a moment. But they say what we are really doing is this is not a constitutional issue. It's not for this court to tell the American people how this issue must be dealt with. It's for the American people to decide within their individual states, through democratic processes, how this issue must be dealt with. And I think a lot of people have misunderstood that issue. The decision doesn't prohibit abortion. All it does is it says you don't have a constitutional right to abortion. That is something you need to decide through your democratic processes. It's not for us to tell you. Of course, it is true that many states have now enacted a very conservative laws around abortion, which have created unhappiness. I haven't studied them in detail, but I believe that Utah, for example, has enacted a very, very restrictive law. From the outset, if I understand, if what I've read is correct, that from the moment of conception, there's no abortion unless it's for therapeutic reasons, i.e., medical reasons. But there are many states in the world that have laws like that. Poland, for example, has a very restrictive law, again from conception, and it's extremely difficult to get an abortion, if at all. So this decision sort of fits in a broader global matrix, and there are only 6 countries in the world that allow abortion beyond 20 weeks. On demand. And so you've now got a varying set of laws state by state in the United States that changes. Each state decides for itself what it will and will not allow. And so there are variances, and that I think has created a lot of heat and a lot of debate. In South Africa, we allow, as I understand it, abortion on demand up to 12 weeks. And then between 12 and 20 weeks, it is still permitted if the mother feels that her social and economic circumstances are such that she wouldn't be able to maintain the child. But beyond 20 weeks, it becomes therapeutic only.
Yes. Okay.
And this sort of benchmark of pre-viability, post-viability abortion is something that is generally been recognized in many states and many countries. The exceptions are places like the Netherlands, Canada, China, North Korea, and so forth. There's a handful where you can have it sort of beyond the viability stage. Okay. And this decision dives into all of those sort of issues and looks at them in detail. But that's the high level. If you want me to give you a little bit more detail on the reasoning and how the court arrived at conclusions, I can do that.
I think, Clem, what I'd like to understand is what was the catalyst for reviewing this? What sort of triggered this review of this? Was there a specific event? Was it an individual? I mean, you mentioned Dodds versus Jackson. Did somebody raise concern about this? What was kind of the trigger point?
So I think that at a very macro level, politically, this has been coming for a long time. Despite, the Trump administration confirmed a number of conservative justices on the Supreme Court bench. There's now a conservative majority. And I think from the perspective of US conservatives, the time was right to bring a matter like this. So that is part of the sort of background matrix. And this particular case was initiated by the state of Mississippi. They, as I understand it, had a law, wished to have a law to the effect that you could only have a non-therapeutic, in other words, a purely voluntary abortion up to the point of 15 weeks, and beyond that, not unless there were medical reasons. I haven't gone back to read the Mississippi law, and look at it. I understand from reading Justice Alito's judgment. And they originally approached the court on the basis that they wanted to understand whether the Constitution prevented them from prohibiting abortion prior to 15 weeks. In other words, were they entitled to limit one's right to abortion? And that was the basis on which they approached the court. And if you read Chief Justice John Roberts's decision, and he's given an independent opinion, it supports the majority opinion in its conclusions. But he does say that when Mississippi originally approached the Supreme Court for a hearing on the matter, and in the US, you don't have a right of appeal like you generally do in South Africa. There, the court decides which matters it will and it won't hear. When the court agreed to hear the matter, it was based upon the principle that the decision would not have to deal with Roe versus Wade and wouldn't have to touch or overturn Roe versus Wade. But after the court had agreed to hear the matter, the position of Mississippi, they then changed their position and attacked Roe versus Wade directly. It's quite clear from John Roberts's opinion that he has certain misgivings about the court having entertained the broader attack, and that he thinks that Mississippi should perhaps have been confined to the original ground. So it's hard to understand exactly what drove that, but certainly I think many people on the liberal part of the spectrum would interpret that as a kind of perhaps some element of subterfuge. I don't know. Perhaps it was a strategy by conservatives to attack this decision. I simply don't know. And I don't have enough background on that. But then they got it before the court, and then they had to deal with this issue. And the court, if you look at the opinion of Justice Alito and you read it, he really says that the US Constitution doesn't expressly mention a right to abortion, and you wouldn't expect it to, given when it was created and the various amendments to it. And that there is, and I'm simplifying because just for the sake of understandability, there is something called the 14th Amendment to the US Constitution, which is referred to as the Due Process Amendment, and that is a statement that nobody may be deprived of life, liberty, or property without due process. And the people who are arguing that there is a right to abortion try to hang that argument on the liberty, the word liberty in the due process clause, and to interpret that word liberty to say it includes a right to abortion. But there are problems with that argument, or potential problems with that argument. So the problem is that due process clause was enacted, I think, in about 1878, after the American Civil War, in order to protect the rights of freed slaves. That's what it was really put in place for. It was never, at the time that 14th Amendment was enacted, there was no concept of a right to abortion. And in fact, most states at that time prohibited it, some absolutely, others possibly with some therapeutic exceptions, but generally US society did not countenance any kind of right to abortion. And he says that word liberty is a very capacious word. And if you don't read it correctly the way the Constitution intended it, if you read it just to mean what you wish it to mean, it becomes unlimited. And that was never the purpose of it. That when they wrote that amendment into the Constitution, that word liberty referred to concepts of liberty which were deeply rooted in American culture and history and tradition, including the culture and history and traditions of the United Kingdom, from which, of course, the
Yes.
Americans had their own background. And so he says you've got to, in order to find a right in that word liberty, that's not, it's something that if something is not expressly mentioned in the Constitution, you want to find an element within that word liberty, which is deeply rooted in our history. And he then goes back and traces the history around the laws relating to abortion from the 13th century, the 1200s in England, and traces it all the way forward to Roe versus Wade. And he says, at a point in time, and you can look at the detail of it in the judgment if you want, abortion was not criminalized pre-quickening, i.e. quickening being the point in time when you can feel the child in the womb, when the child moves in the womb. Because that was considered the time the quickening was considered the indicator of life. But later, legislation actually prohibited abortion pre-quickening. And by the time you get to Roe versus Wade, generally across the United States, there was a general prohibition of abortion. And that by the time you get to Roe versus Wade, the vast majority of American states had statutes that specifically prohibited abortion. So he says abortion was never, a right to abortion had never been part of the American tradition. And so therefore you can't read it into the word liberty. He then deals with Roe versus Wade and says Roe versus Wade said, well, we think there is a right to abortion to be found somewhere in the American Constitution, but they never said exactly where it is to be found. And they said they thought that it might be found in the word liberty, but it never firmly rooted the finding in the American Constitution. And so therefore, it became, I think, probably from the outset, an assailable decision. Some scholars will tell you that the Constitutional Court used to write its decisions in a different way in those days, in sort of more expansive. And so there is that argument. I'm simply telling you what Justice Alito says in his majority decision. So he says that is fundamentally a problem. And then along came Casey, which is another case which also didn't really solve that problem. It tried to then tie it more firmly to, some people have subsequently tried to tie it more firmly into the 14th Amendment, but you don't really get there because of reasons that have been that I've referred to. So this is the sort of the underlying rationale of the decision that Roe versus Wade was never properly founded. And then, he deals with the question of what lawyers call stare decisis, which is the question of precedent. In other words, that a court must respect its previous decisions, and courts must respect the decisions of other courts, and particularly superior courts. But the reality is that courts do overturn their own historic decisions from time to time, not unique to the United States at all. And he points to a number of different decisions where courts have overturned, including the Supreme Court of the United States has overturned its own previous decisions. And he refers to, in particular, which I found quite interesting, to the case of Plessy versus Ferguson. Now, Plessy versus Ferguson was a post-Civil War case which came before the United States Supreme Court, I think about 1886 or thereabouts. I have the date exactly right, but it's in that sort of time frame. And Plessy versus Ferguson concerned a man who was 7/8 white and 1/8 black. An octoroon, as they used to call it in the American South, because that
grief.
Who had decided to use a public transport service, a bus or an omnibus of some kind, I suppose an animal-drawn vehicle, which had been reserved for whites. And so he was challenging what was really what we in South Africa would call an apartheid law, separate but equal, that concept. Which had been written into the legislation by various of the states. And in that particular case, the United States Supreme Court actually upheld that law. In other words, they upheld the separate but equal law. They entrenched what
Okay.
we call an apartheid law and said,
Mm.
well, that's part of the American it's constitutional. It took until 1954 in Brown versus the Board of Education for the Supreme Court of the United
Yes.
States to turn around and say, well, that decision was incorrect and we're overturning it.
Mm.
So that's not to say that the overturning of Roe versus Wade stands on the same footing, but it's simply to say that courts do overturn their own decisions sometimes. When a later court finds that the reasoning was faulty for whatever reason. And obviously, I think also social circumstances change and values
Yeah.
change. So this is the background against which this sort of overturning of this case occurred. So a lot of people, I think, are of the impression that the US Supreme Court has prohibited abortion. That's not what it's done.
Yeah.
All it has said is, this is not our decision, folks. This is your decision. You, the American people, have to decide on this issue through normal democratic processes.
Because Clem, if I look at what you're saying, it's like this whole thing from the word go was incredibly thin. I mean, it was never really rock solid. I mean, you've got people like Ruth Bader Ginsburg, who's incredibly well respected, questioning this right from the word go. And if we take I almost want to say, and I know this is very hard, but almost take the emotional rights issue out of this from a legal basis, this whole thing, it was always shaky, and it was always going to be a little bit shaky, and it was never really rock solid, and we can hang our hats on this from what I'm, this my interpretation of this whole thing. It was always potentially going to be blown out of the water, and it was really just a matter of time before that happened.
Nicci, yes and no. Let me deal with the yes part first. In the majority decision, the point is that even people who agree that people should be permitted an abortion, he refers here to a scholar by the name of John Hart Ely, Ely. And who was somebody he was an academic commentator who was very pro-abortion, and he says famously wrote that Roe versus Wade was, quote, not constitutional law and gave almost no sense of an obligation to try to be, close quote. So there was that view even amongst liberals, and elsewhere it was described as being an exercise in raw judicial power. In other words, an inappropriate use of judicial authority. There is that view. But there is another view. And it turns again upon this question of, how do you interpret the Constitution? Do you interpret it on an originalist basis, what people intended at the time that they wrote the Constitution, or do you take a more expansive view towards it and say, we need to keep on reinterpreting it as our society develops, as circumstances changes, and as values change within our society, of our society change. There are these two very different views, and it's not always the rule, but it's often the case that the conservative justices tend towards a more originalist interpretation, and the more liberal justices tend towards a more expansive interpretation. So the thing becomes a matter of philosophy. How do you interpret this? And it's quite interesting because when you talk about abortion, you've got this question of the rights of the mother, the individual concerned to determine their own future. And at the other hand, you've got this philosophical question of the rights of what is sometimes referred to as an unborn human being. It's this balancing approach, and a lot of that is informed by people's personal value systems, and sometimes by their religious or philosophical beliefs. And that is why you have these very divergent and sometimes heated opinions around this issue. So, it's not a debate without its nuances, either at a philosophical level or at a legal level. And it certainly has its challenges. And I think I put on my Facebook page a while back a short indicator which I'd drawn off the New York Times of what the average profile is of the American person who seeks an abortion. And it's typically an unmarried mother who already has a child and is in difficult economic circumstances. So these are things that one needs to think about, and another commentator who has an alternative view said, it's all very well to be opposed to abortion, but where are you when the child is born and the economic circumstances are very difficult? So there are elements in the debate, but there is another view. I remember that I first read quite a few years back about some nuns who had been raped in what was then the Congo, I think in the unrest in the 1950s, late 50s or thereabouts. And they had refused to abort the children, which were the consequence of that rape, because of their deep religious belief that life begins at conception. So you've got that the spectrum as well, and how you marry these views, and how you get to some sort of sense of social. You'll never get to perfect social consensus, but broad social consensus on these issues, I think, is difficult. And the only way you do that is through ongoing debate and engagement. And eventually, within a particular society, you might reach a point where there's some sort of central core of a view around this issue. In South Africa, as I know, it's not such a heated issue.
Yeah. But so, Clem, you've painted a really great picture of the background and the history, and how we got here. What are the implications of this? What happens now? Because from what I've been hearing in the media and stuff that I've been reading and listening to, it seems like there's a state of chaos around this issue, because there were certain states that had these trigger laws that were linked to Roe versus Wade, where abortion bans came into effect almost immediately, like as the minute the judgment was overturned. Then you've got, generally, as you said, your more blue states who, this has always been legal. We have certain parameters, but things are going to carry on. And then you've got other states who are still kind of trying to figure out what the way forward looks like. So what are the implications, both from a short-term and a long-term perspective around this? Like, what happens now?
Look, I think let's put it this way. As far as I'm aware, in no state in the United States was non-therapeutic abortion permitted beyond about 20 weeks, which is sort of there seems to be a view that is the sort of viability point. So the question is really, is therapeutic abortion permitted beyond that point, and what happens before that point? And it's quite clear that there are going to be widely differing laws from state to state. I was reading an article earlier this morning written by a medical practitioner, I think, in the state of Ohio, an obstetrician. He's an obstetrician, I think, and his wife is a pediatrician, if I recall correctly. And it's an article written in the New York Times today. And he was just saying that the new laws in Ohio do not permit them to now abort a child beyond a certain point, I think after 6 weeks, if that child may be defective. And he's saying the problem is you may not even know, depending upon your biology and your weight and your makeup as a woman, that you may not know at 6 weeks. You may not even know that you're pregnant.
Yeah, exactly.
So, and that they are now forcing these women into a situation where they have to carry to term a child which they know is defective or that may die shortly after birth. That was, as I read and understood the article, which I think is pretty hard. It's pretty hard, I think, for you as a mother not to have the choice of saying, well, I'm going to have a child that will probably not live long after birth. And you're now forcing me to carry this child to full term. And he said, it's heartbreaking because, for example, these people will go out in public, they'll go to a supermarket and, they may bump into somebody they know who sees that they're very pregnant and they're congratulated on this. And you can imagine the how one feels about that. So, and then of course there are people who will be able to cross state boundaries to get abortions, but others who won't. I don't know whether some states may try to prohibit that as well. So you are going to have, I think, quite different laws within the various states around this issue. And I think what Roe versus Wade perhaps did unintentionally was to raise the temperature around this abortion issue in a way that perhaps didn't exist prior to Roe versus Wade. And so that democratic process of trying to arrive at some sort of consensus within each state as to what we're okay with, given our value system within whichever state it is going to perhaps be a more difficult process now than it would have been because people have now sort of assumed positions around this. The question is often asked, what does this mean for other laws, which are liberal nature, such as, gay rights and so forth, and, same-sex marriages, and so that are these at risk?
Yeah, exactly.
And there's a lot of, I think, fear around that, and it's quite hard to arrive, I think, at any sort of clear conclusion as to where those will go to, because firstly, this was not Roe versus. It depends on how you look at it and how you choose to characterize or color the thing. But Roe versus Wade was, in a sense, an act of judicial activism, creating something. Whereas this decision says we're not going hands-on like Roe versus Wade, we're actually going hands-off. So we're not telling you what it must be. What we're telling you is that we can't tell you what it must be. That's for you to decide. So it's for each state to decide. So in a sense, it's the converse of that fear. But the political reality is, of course, that many of the states are conservative. So when the Supreme Court goes hands off, the states go hands on. So it's quite a difficult issue. But there is, I think, some grounds for liberals not to be quite as pessimistic when I look at this particular decision, and my view may prove to be completely misplaced in the long run. But Justice Alito says he addresses this concern. He doesn't address it as fully as we would like, but he doesn't completely ignore it either. And he says that you need to recognize that the question of abortion in this spectrum of liberal concerns, if I can put it that way, those are not the words he uses, those are the words I use. But he says that this question of abortion is unique in the sense that you have the rights of the mother on the one hand, this life, but you have another life that you are weighing up against that. And so therefore, you don't have this factor of another life that's in the balance when you're dealing with other types of rights.
Okay.
And so therefore, this is a unique thing we need to deal with. Now, that the message that you hear is, folks, don't overread this thing. It doesn't mean that other rights are not at risk. But you need to recognize as well that this sits within the matrix of American politics, and people are concerned. and nobody knows how that all plays out in the long run. So quite difficult to predict, Nicci. I wouldn't say that fears are misplaced given the conservative majority on the bench, but Justice Alito did try to say that this is actually a uniquely difficult issue that the court needs to deal with. How it goes, I have no idea in the future. This is, something we will only know as the game goes along.
And Clem, what about? I mean, I don't know if you are in a position to speak to this. What about the shifts within the Supreme Court? So we've got I can never pronounce her first name, Ketanji Jackson Brown, who's recently come in as she's not actually in the Supreme Court yet, but she will be coming in soon as one of the justices. Will that have any implications in shifting this very strong conservative Supreme Court that you have? I mean, can you talk to me about that?
So it's not something I've looked at in detail. I've obviously watched the
hearings,
the shift. It was some of the hearings. I watched Justice Kavanaugh's confirmation hearing with some interest. It was quite, as you know, quite fraught. Obviously, the Trump administration had the good fortune to appoint a number of justices of a conservative bench, and that, I think, was partly a function of long planning on the part of Mitch McConnell, or so many liberals would say, the leader of the GOP. But it is difficult to see that this conservative majority is going to be displaced anywhere in the near future. They are in the US system, a Supreme Court justice stays a Supreme Court justice until they either choose to resign or, the end of life, until lives end. As was very much the case, for example, with Justice Ginsburg, who hung in there as long as she could because I think she was aware of this shifting balance of power. My impression is that the Chief Justice John Roberts, and again, I'm not a close watcher of the U.S. Supreme Court. I'm not an American legal scholar. That he tries to act as a somewhat balancing effect, but at this point in time, it's clear that the conservative majority has the upper hand, and we should expect to see ongoing, and it already is the case, ongoing more conservative decisions from this court over the coming years. So that is the reality. But one needs to bear in mind that, as with all things in life, the pendulum does eventually swing. It's only a matter of time. Sometimes, as you've seen now, I referred to Plessy earlier, which took 60 or 70 years to be overturned, and Roe versus Wade, a similar sort of window of time, 50 odd years. The pendulum does swing. So nothing is permanent, that is for sure. And there will come a day in the future when the conservative part of the bench will be in a minority, because it's just how life works.
I mean, do you think that, as much as I am radically pro-choice, so I'm making the statement with that in mind, but I am also the eternal optimist, and my sort of sense check around this is almost that there could also be some really good things that come out of this. I mean, as you said, the whole abortion debate has now been sparked, and we're having conversations about it that we certainly weren't having 5 years ago, 3 years ago, even 6 months ago. This whole thing has become a lot more topical, and we are having these discussions and having these debates. But there's also conversations that I'm hearing around now limiting or giving the Supreme Court justices terms, and actually saying you can only serve a limited amount of terms. So it doesn't become this lifetime or until you decide otherwise commitment. So it does feel like there's certain debates that are coming out of this, which are very good and very necessary.
Well, I think that the one thing you can be sure of is that the political temperature around this thing is not going to go down for a very long time. And there is going to be a lot that is written and said around, it's already the case and will continue to be the case, a huge amount that is written and said around, not only the question of abortion, but around the question of the Supreme Court itself. The Liberals, as you will have seen, are deeply unhappy. There was even at one stage a suggestion of increasing the number of justices on the bench so that they could add more Liberals. That's known as court packing and has happened in various countries in the past. If I recall correctly, the National Party once tried it in this country, and it didn't quite work in their favor because they found that the justices that they appointed didn't always vote the way they wanted them to.
Oh, whoops.
Lawyers have notorious, many, not all of them, but many have a habit of proving to be, shall I say, from the perspective of a politician, can prove to be regrettably independent-minded, which is a good thing, of course. So this issue is not going away, but my understanding is that to change the system so that justices only have a limited term is not something that will be easily achieved in the United States. I speak under conviction, but my impression is that these principles are entrenched in the US Constitution. I would be surprised if they're not. And if I am correct on that, then changing that is going to be no mean feat. But Americans have shown that when a thing gets to a certain point, they will work together across party divides on certain issues. You will have seen there is now already some shift in the firearms environment. There's been some bipartisan work there to try and I wouldn't say put a lid on, but to try to limit, to try to put some kind of boundaries around these issues, which are resulting in these mass shootings, which are a problem for all concerned. And no sane American wants to see that kind of thing happen. The question is, what is the best way to prevent it? And we are starting to see a little bit of movement on that. And it may be that around these issues, over time, people will start to find each other, as these democratic processes happen. But there's going to be an enormous amount of shouting in the meantime, and it's going to be, I think, a very lengthy process. But in a sense now, we are back where we were before Roe versus Wade, and that democratic process now needs to pick up. And so I think there's going to be a lot of fighting. The battle moves now from the Supreme Court to the states and to the state legislatures, to that sort of environment. So there's going to be a lot of, shall we say, vigorous political interaction around these issues. And particularly, I think for people who feel as strongly about it as you do, people in the US who feel very strongly about it. And there will be states which are more liberal, where it will be less of a fraught issue within the state. It's going to be interesting to watch at an academic level to see how this debate develops over, quite frankly, the coming decades, because this is not going to be a thing that's going to change in a year or two.
Absolutely. Absolutely. Well, Clem, I mean, this has been absolutely fascinating. As always, it's always fascinating for me to have a chat to you. But thank you very much for sharing your views and your insights. And yeah, it really has been interesting. And you've definitely given me insight that I didn't have before. And it has helped, I wouldn't say quell my rage, but put my rage into perspective. So thank you for that. But Clem, where can people, if people want to get in touch with you, or I mean, I did mention follow you on Facebook, but if people do want to reach out to you, where's the best way to get hold of you?
Well, I have a LinkedIn profile, and I have a publicly accessible Facebook page where I post thoughts, and sometimes they're a little bit controversial, but and not controversial, but give a different view, a different perspective of things. And I'm quite easily findable on Google. If you Google me, you'll find me. You should find my email address without too many difficulties. So I'm generally contactable if people want to talk to me about something. And I am one of those people. I tend to avoid dogmatism, and I always look for the nuance in the discussion and the perspective, because I always recognize that there are quite different views. And as you know, I'm interested in a lot of different things, different perspectives. So, Nicci, thank you very much. It's been wonderful talking to you.
Thank you.
And maybe we'll do something on another topic some other time. Take care.
I certainly hope so. Clem, thanks very much. And thanks everybody for joining us. I hope you found this as fascinating as I did. There will be a recording. If you want to get that delivered straight to you, please sign up for my mailing list. But otherwise, take care, everybody. Have a wonderful weekend, and I will see you next week. Bye-bye.